Welcome to Business Law 1 class, Unit 1, Section 3, Evolution of the Principles of Common Law and Judicial Precedent. By the end of this session, you should be able to explain how the common law developed, explain the importance of judicial precedent within the common law countries. The evolution of common law. Before the Norman conquest in 1016, different areas of law were governed the system of England. So it means that before that time, England used different system of laws. In 1016, the king, William the Conqueror, gained the English throne. That's when he became the king. When he became the king, he established the central government. After establishing the central government, he then standardized the law. After doing that, he also set out or appointed representatives of the king, and these representatives were sent to go to the various countries, villages, or towns, nearby towns, or outside the place of England to settle cases. So they were sent to the, let me say, the rural areas around that time to settle their disputes. It's like we have Ghana, Accra being the central, then the government or the president has appointed people to go outside Accra to adjudicate cases. Now, after they had finished after they have done with the settlement of disputes, then they went back to Westminster. At Westminster, this representative discussed the law, the one which they think that it should be kept and the one which they think that it should be dismissed. In that area or during that system, what happened is that they use what you call rates. So each case has its own rates. So different rates were applicable or adopted for different course of action. So if you have a course of action, if you have a case, if you have a case, you have to go to the king and look for or buy the exact rate that will suit your case. It means that if you don't get a rate that suits your case, you cannot file your case. Because of this procedure, the system was too rigid to achieve justice, in that when you don't get the exact rate for your case, you can't file your case. So you'll be thinking about issues of corruption, because the rates are being, you have to purchase the rates. The rich people were buying the rates, so that if you are a poor person, you cannot buy the rate, or before you get there, the rate is finished, and you cannot file your case, and it led to injustice. Now the only available that that system was given was damages. Under that system, you only get damages as a remedy for someone breaching or someone having issue against you, or someone who want to deceive you or want to take advantage over you. So even if you have entered into a contract with a person for sale of land, you cannot ask for a specific performance. The only remedy you can get is damages. So sometimes you know that it is not the monetary value that the person needs. The person needs the item itself. But there was no way that the person can get the item in question, only to be paid off. So you understand that the rich will be taking undue advantage over the poor at that time. Now, owing to this, the court of equity was developed, and which was also known as the court of chancery. This court of equity apply the principles of equity based on the laws of Roman law and natural law, but it does not apply. It doesn't apply only the common law. So it was the court of equity was applying Roman law and natural law to achieve justice or achieve an outcome that was favorable to all the parties. Now, in this system, parties were allowed to present their issues in vernacular language, that's in their own language, as compared to the previous system whereby it was you have to deal with Latin. Now, the court of equity or equity brought additional remedy, for instance, specific performance, injunction, and also recognize the interest of beneficiary under a trust. So specific performance is whereby you are supposed to do what you are undertook to do under the contract. Injunction is whereby a court issue order for a person to do or refrain from doing an act. For beneficiary, this is where the settler vests property in the hands of the trustee for the benefit of the beneficiary. So the court of equity gave the chance to the beneficiary to sue the trustee in case the trustee is mismanaging the property. Also, the chancellor did not follow any binding rules. They rely solely on the chancellor's view of right and wrong, and for that reason, right was not recognized by common law, became enforceable. So what this means is that, look, under court of equity, the chancery did not apply. The chancery uses conscience. So what the chancery will say is right is the law. So if you go and chancery is in the right mood and chancery say, well, this is how it should be done, that should be the law. And you should understand that because of you are the person just applying his own view, whatever comes to mind that he thinks it is the law, that will be the law. So you see, this one could lead to other issues. The court of chancery became popular and caused resentment among the common law lawyers who argued that the quality of decision depended on the quality of chancellors because precedents were not followed and each case considered on the merit. So the common law lawyers were not happy because there is no precedent for the chancery to follow. When you go based on what he thinks, that's what he's going to give judgment on, or he will pass judgment based on his own conscience. But the common law lawyers will see there should be an existing law to serve as a precedent. Now, because of that, there was a conflicting judgment of common law court and the court of chancery were referred to the king for decision, and he advised that where there was conflict, equity should prevail. So they were applying, you have the common law court, you have the equity law court. Common law court will give this judgment. The same case, they will send it to the court of equity. They will give different judgments. So they may send the case to the king. And then say that, look, when there's conflict between equity and the law, equity should prevail. Now, this principle continued for several years. Then a law was passed, that's the Judicature Act of 1873 to 75 was passed, and it provided that equity and common law could be administered by all courts. The Judicature Act did not fuse common law and equity. So what you are saying that, look, a court can apply both equity and common law at the same time. So if a court and a matter come before you, you look at the principles of common law, you look at the principles of equity and you give judgment. But it is not fuse the two. Now it must noted that equity follows the law but not slavishly, which means that the court will first apply common law, but where the application of common law will lead to injustice, equity must prevail. So as you indicated, first, a court have the right to apply both equity and common law. But first of all, the court must apply or consider the common law first. When you apply the common law and the result that you get, you will not get fair or judgment which is just, then you apply the equity. So equity was to be considered second. That you only consider equity when the application of the common law will not make sense. Or where they conflict, then you take the position of equity. Now let's consider judicial precedence. Judicial precedence means the process whereby judges follow previous decided cases where the facts are of sufficient similarity. What this means is that for judicial precedent, a court or a judge will follow a particular case that was decided earlier if the present case has more similarity as compared to those cases decided earlier. A typical, you can answer by taking this position. For instance, when someone kills another person, you say that the person has committed murder. If all the ingredients of murder are established, now subsequently, if another person kills someone, then because the facts are similar, you apply the law that we applied in the previous case. This gave us the Latin stare decisis e non quita. So let me take it again. The system of precedence is based on the Latin maxim stare decisis e non quita movere. This principle means that stand by what has been decided and do not unsettle the established. So it simply means that follow the previous decisions, which have been firmly established, but don't depart from it. This provides certainty and predictability in the law. So we mean that the issue of stare decisis, that requires that you follow the previous judgment, don't depart from it, brought certainty and predictability, because you know that when this issue happens, this is how you solve it. So if similar issue of that nature happens subsequently, you are going to apply the same rule. Now, the decision of court may fall into two parts. If you pick a court decision, we have a component which is the ratio decidendi. The ratio decidendi is the reasoning or the reason for the decision. That is the binding aspect of the judgment. Then you also have what you call the obiter dictum. The obiter dictum is not the ruling, but something said by the way. So the obiter dictum is not the judgment itself. It's something that the court said, if the thing is like that, this would have been the case. But the ratio decidendi is the binding decision. So anytime you are reading cases, you look for what you call the ratio decidendi. That is the reason for the decision, and the same as the judgment itself. The court will give judgment and give the reason why he's giving the judgment. I must tell you that sometimes it is difficult to differentiate between the ratio decidendi and obiter dictum. It requires consistent reading and skills for detecting which one is the ratio decidendi, and which one is the obiter due to. Types of precedents. Now you have the original precedent. That's the original precedent is when a case come before the court and it is the first time. The decision that will be made is the original precedent, so that subsequent cases will follow that with similar facts will follow that judgment. You also have the binding precedent. The binding precedent is the aspect of the judgment or the case that binds the court below the court which gave the judgment. So for instance, if you take the Supreme Court, if they give judgment, all other courts below them must follow that judgment. That the judgment of the Supreme Court is a binding precedent to all the courts below it. You also have persuasive precedent. Persuasive precedent, this decision is not binding, but the judge or the court may consider that this judgment is persuasive or is more convincing, and I have to adopt that one. It is not compulsory. The judge can depart from, decide to choose or ignore. Advantages of judicial precedent. Judicial precedent is a practical in character. You are saying that it is practical in character in that so we can also say that it ensures impartiality of judges. Now look, the rules are there. This is this. If you do that, this is the law. If you do that, this is the law. So it does not allow the judges to use their own judgment or what they think. You apply the law as it is. You follow the precedent. Another advantage that you can talk about is that it avoids mistakes. It avoids mistakes. So because the law is there, there's no mistake. You not commit too much mistakes. It brings certainty. You know that per the facts of the case, in previous one when the case was like this how the judge ruled. So certainly this one too will go this way. It's also opportunity to develop the law. It is time saving. It is too rigid. It is too rigid. You also understand that the judicial precedent can be complex one. Mistake can be easily perpetrated. So this aspect is more of disadvantages of judicial precedent. We have noted that the common law system developed in 1066 AD by the English. Later, the Chancery Court emerged today with short forms of the common law system. We have also noted that judicial precedent developed with the evolution of the common law and provide a vital source of law in the administration of justice with its accompanying advantages and disadvantages. Thank you and have a nice day.